Welcome everyone. Thank you for joining us today for our webinar, Get Ready to Renew with FDA, How to Prepare for the Renewal Window Opens. Throughout this webinar, feel free to write any questions in the Q&A box, and we've saved time at the end to answer them. We'll also follow up with a link to the recording so you can refer back to this at any time. I'm proud to introduce our expert speaker today, Melissa Sawyers. Melissa is Registrar Corp's drug team's manager, brings over a decade of expertise in analytical research. As a head of the drug division at Registrar Corp, she has spent nearly 15 years guiding companies with her team through complex filings and registrations. Her specialization lies in SPL and ECTD submissions to regulatory agencies across the globe, making her a trusted expert in navigating regulatory compliance. Without any further ado, Melissa, please take it away.
Thank you, Sophia, for the introduction. Good day, everyone. We'll be going over in today's webinar regulations that affect drug manufacturers during the period where renewal of submissions are required to be compliant with FDA. Manufacturers need to be aware of the regulations that apply to them by the United States Food and Drug Administration when manufacturing within the United States or for import into the United States. Let's dive deeper within each of these topics. We will not assume that everyone in attendance is a manufacturer. How an agency defines manufacturer varies from agency to agency. For today's webinar, we are focusing on the regulations within the United States. With that being said, when it comes to being defined a manufacturer, it is a facility that is engaged in the activity of making a drug product, not the formula owner or the brand owner. Activities that fall within the manufacturer definition include analysis, packers, repackers, labelers, and relabelers are subject to the requirements we will be discussing in today's webinar, unless otherwise specified. FDA has another role definition that may apply to the formula or brand owner. This role is called the private label distributor. This is the company who is not manufacturing the product, but has a contract with another company who manufactures the product. The first submission type that will require attention during the renewal window are establishment registrations for manufacturers. If you are currently engaged in the manufacture of drug products for commercial distribution in the United States, you should have already filed an establishment registration with the FDA. These submissions inform the agency who is manufacturing drug products within the US or will be offered for import into the United States. When an establishment is registered with FDA, it is subject to an inspection by the FDA at any time and without notice. These facilities are required to follow the current good manufacturing practice CGMP's requirements to ensure the quality and safety of the products to the consumers. Manufacture is a broad term as it encompasses business operations such as pack, repack, label, relabel, salvage, and analysis for those intended to be released product. Establishment registrations are not only required for the finished drug products, but also for the bulk product for finished drug products, further manufacturing, including active pharmaceutical ingredients. Excipients or inactive ingredients are exempt from this requirement. Also, it is important to note that this requirement is also applicable not only for drugs intended for human use, but also for animal use, including medicated animal feed. Manufacturers located within the US are required to register with FDA even if the product is for export only. Manufacturers not located within the US, if the product, including active pharmaceutical ingredients, are to be further manufactured into a product and then offered for import, are required to register with the United States Food and Drug Administration. There are exemptions to who is required to register its facility. These are facilities that are in a medical setting, not producing for mass distribution. Those that are focused on drugs for clinical, teaching, or analysis, that is not intended for sale or distribution. These are usually drugs that are filed under an investigational new drug application, an IND. Those that are shipping companies like FedEx would not be subject to the requirement. As mentioned prior, manufacturers of exclusively inactive or excipient ingredients would be exempt from this requirement as well. What goes into a registration? As a refresher to those who have filed, and anyone who may have joined who have yet to complete their registration, an establishment registration naturally will include the company name and address. It must be the site that the drug products are being produced. Providing the site of a headquarters instead of the manufacturing facility in the registration as the physical address would have FDA showing up at the wrong address to inspect. Needless to say, that will not go over well. FDA does have other mechanisms in place to verify, such as a request for records by email is a very common request by FDA to verify the operations of a facility that has registered. A DUNS number, known as a Data Universal Number System, is a unique 9-digit number assigned to a facility by a private entity called Dun & Bradstreet. FDA has a connection with its database to verify when an establishment registration is submitted, it matches the record Dun & Bradstreet has on file. This is a required unique identifier by the FDA and does not require a fee to obtain a number or update an existing record. If you opt into their additional services, that is a decision for your company. However, for the purposes of FDA, a fee is not required for this purpose. Registrar Corp has a team who helps our clients with this process. The establishment registration also includes identifying the type of operations that are occurring at the site, such as manufacture, repack, relabel, analysis. Then the type of products need to be identified. Are the products being manufactured intended for human or animal use? Are the products marketed under an approved application, over-the-counter monograph, or are the products unapproved? Then FDA also wants to know who to contact at the company. The establishment contact can be, in this case, any other site for FDA to send correspondence to. For sites that are not located within the United States, the U.S. agent's details are required, as well as each U.S. importer. It is very important to include the U.S. importer on a registration prior to shipping. This is the most common charge we see on notice of actions. All this information must be reviewed and verified during the renewal period. Do you know if your establishment is registered? FDA has a public database that companies can use to verify if a site is registered. It is an easy site to use. Just make sure that you enter a partial name because any variation from what is registered at the facility will not appear in the results. Does anyone in the audience want to type in their company name for us to see if it pops up? So here's the FDA's Drug Establishment Registration site. I'm just going to type in a few words just to see what comes up. So when you type in a portion of it, if anything like changes, like there's a punctuation or abbreviations and it's not exact, it won't show. So that's why I always say to do a partial. But you can see what companies are currently registered with FDA, their FEI number, their DUNS number, what operations occur at that facility, the address that the production is occurring at, as well as the expiration date for that registration. When the facility appears in the results during the renewal window, it will indicate whether the facility re-registered for the following calendar year in the registration expiration date column. Please take note that when an establishment appears in these results, this does not mean that the site has been approved by FDA in any means. If you make any claims that this denotes approval of any sort by the FDA, it can subject the responsible person of the establishment to misbranding charges that may involve fines or even criminal charges. There are certain changes that must be submitted to FDA when they occur. When there are legal changes to the company's information, it is important to update the registration. Also, make sure that the importer is listed on the registration prior to shipping to the US. The compliance officers do cross-check this. Any changes to a company's business operation must be reflected by updating the drug establishment registration with the FDA. The FDA has established standardized terms and codes for business operations. These operations describe the specific activities performed for a drug product, such as manufacture, active pharmaceutical ingredient manufacture, relabel, pack, and others. Each business operation may also include a business operation qualifier, which provide more detailed information about the activity. For example, manufactures animal over-the-counter products or manufactures human prescription drug products. When the United States agent changes, it is important that this is updated to ensure communications from the FDA are received. If the business closes or the facility is no longer manufacturing drug products, notifications to FDA must be submitted. All these updates must be submitted to FDA within 30 days of the change. Between October 1st and December 31st, manufacturers are required to review its registration and update the information on file, or file a no change notification to re-register for the next calendar year. It is important to complete this during the renewal period to ensure that there is no lapse in the registration status that could impact shipments arriving at the start of the new year. Another submission type that manufacturers are sometimes required to file with FDA is the labeler code. This is where, when authorized by the manufacturer, private label distributors may submit to FDA. So, what is a labeler code? If this is a term you have not heard before, it is a number that is assigned by FDA to assign unique numbers when listing a product with FDA. This unique number is known as the National Drug Code, shortened as the NDC number. We will be diving in more detail on product listings shortly. Unlike an establishment registration that is site-specific, a labeler code belongs to a company. So if a company owns multiple sites, only one labeler code is used for the assignment of NDC numbers for products manufactured at each of its sites. Manufacturers that are exempt from establishment registration requirements are also exempt from obtaining a labeler code. However, not all manufacturers that are required to register its establishment with FDA are required to obtain a labeler code. If a site handles only medicated animal feed that are type B or C, then it is exempt from obtaining a labeler code. If a site manufactures type A medicated animal feed, then a labeler code will need to be obtained. For sites that pack, repack, label, or relabel, all these operations require a labeler code assigned unless it is handling only medicated animal feed that are type B or C. Laboratories that perform analysis for release testing are required to register its site, but will be exempt from obtaining a labeler code. Now, unlike manufacturers, private label distributors will need a labeler code assigned to its company, if not already assigned. The manufacturer is required for this submission. For animal drug manufacturers, if your site only manufactures by contract, then you will not need a labeler code for your company, only for the private label distributor. Like the establishment registration submission, the company name and physical address must be provided. Virtual addresses are not accepted by FDA. Even though Dun & Bradstreet may assign a DUNS number to a virtual address, FDA does review the request and verifies on its end. FDA does reject labeler code requests if the address provided is not a physical location. Contact information is required in the submission for FDA to contact and verify the facility's operation. The business operation and qualifier is also required in the submission type. This is the one that will include the function distribute for the private label distributor companies. For firms not located in the United States, a United States agent will need to be designated. This is a role Registrar Corp helps many companies with. Unlike the drug establishment registration site that has a searchable database, FDA has a downloadable spreadsheet you can use to verify if your firm or your private label distributor has an active labeler code filed with FDA. Once again, when a firm is on this list, it does not denote any approval by the FDA. Note that earlier I stated active labeler codes. This list is not an exhaustive list of labeler codes assigned by FDA. FDA inactivates labeler codes of firms that did not list within 2 years of assignment. Also, firms can inactivate its labeler code when it's no longer engaged in the manufacture or distribution of drug products. There is a process to reactivating labeler codes with FDA, which we help our clients as needed with this process. Unlike the establishment registration, there's no renewal window for the labeler code. It is required to update when there is a change. So when an update is needed for the registration, it is best to always review when the information to file for a labeler code request filing. This is one submission you can review today and verify, and it's up to date without having to remember to do it again during the renewal period. Listings. This is the last submission type that we will go over today, the product listings. The purpose for these filings to FDA is to create a database of drug products that are being commercially distributed within the United States. These listings provide information such as who is processing the drug and who is distributing the drug product under its own label. In these listings, a copy of the drug label is included. For prescription drugs, the packet insert is typed out in a structured format. A description of all the drug's ingredients, including the strength of the active ingredient, the category that the product is going to be marketed under, such as an over-the-counter monograph, application type, bulk ingredient, drug for further processing, or unapproved. The listing will also indicate the type of packaging, such as a bottle in a box, as well as the size in mass, volume, or units. Depending on the drug's, additional information may also be required, such as the DEA schedule for controlled drug substances, characteristics for solid forms like color, size, imprint, or flavor as applicable. This submission type is the lengthiest and most complex to file with FDA. The facilities that were exempt from the labeler code requirement are exempt from the listing requirement. Note that foreign establishments that do not import directly into the United States, but its product is further manufactured at another non-US site prior to being offered to import into the United States, are also not required to list with FDA. However, a firm may proceed with filing listings with FDA if it wishes in the event a compliance officer rules that it is required. It can help prevent issues during an inspection. It is less likely to be an issue when importing as the NDC number from the manufacturer to be named on the entry documentation will be the most recent facility that processed the product. Previously, we mentioned a number that is uniquely assigned to a drug product in a listing submission. That is the NDC number, which is the National Drug Code number. The NDC number is composed of 3 segments. The first is the number that is assigned by FDA, the labeler code that belongs to a company. The second segment is the product code, which identifies the proprietary name, generic product name, formulation, dosage form, route of administration, marketing category, and characteristics of a drug product. The third segment is unique to the packaging. So if a product is packaged in a jar versus a bottle, a unique NDC number would need to be assigned to both with a different number for the third segment. This is also true when the packaging type is the same, but the quantity of the drug is different. For example, if one package has 15 milliliters and another has 40 milliliters, These would require separate NDC numbers where the third segment is unique. It is very important to assign NDC numbers to drug products only. Do not assign NDC numbers to medical devices or supplements. Assigning an NDC number to anything other than a drug product can constitute as misbranding and subject the firm to penalties. For companies who have been around a long time, you may see 4-digit labeler codes in NDC number assignments. For these, there is only one configuration for a labeler code with 4 digits. It will follow 442 pattern. For the 5-digit labeler code, most common one you will see, there will be 2 configurations that can be used, either a 541 pattern or a 532 pattern. A 541 configuration is great for those that have many different products, but not many package variations. A 532 configuration is great for companies with those that have many different package variations for its products. It's important to note that once a configuration is selected in the first listing submission to FDA, then that configuration has to be used for all subsequent NDC number assignments utilizing that labeler code. FDA is limited in the number of labeler codes to assign left with the 5 digits. Therefore, FDA is doing more research and requesting more information when request for an assignment of a labeler code is filed. FDA expects a listing to shortly follow when a labeler code is filed. And once all those 5-digit labeler codes have been assigned, FDA will go to a 6-digit labeler code, expanding the NDC numbers to digits of 11 digits instead of 10. So when does a new NDC number be assigned? There are certain criteria that will require a new NDC number assignment. If there is a change to the proprietary name or generic name, a new product code will need to be assigned. When there is a change to the active ingredient, a new product code will need to be assigned. If there's only a change in the inactive ingredients, and it is an update to the formulation, you may proceed without filing a new listing. However, if both formulations are intended to be marketed at the same time, then it would be prudent to list as separate NDC numbers. If the dosage form or characteristics such as size, shape, color, code, imprint, flavor, or scoring of a tablet is different, then a new product code would need to be assigned. When a product goes from prescription to over-the-counter status like Claritin did years back, then a new NDC number would be required when switching over to the OTC status. If the intended use changes from human to animal, animal to human, or is intended to be marketed under both intended use, separate NDC numbers would be required. What changes require continuing with the new NDC number? And we're going to talk specifically about the third segment. So when there is a change in the package size, such as the amount of volume, mass, or the number of units within a package, then the NDC number would keep the same product code, the second segment, but have a unique package code for each package size. This is also the case when there are different package types, such as a jar that is sold individually versus a jar that's sold in a box. Each of these would require a separate NDC number with a unique package code for each package size, with the 2 first segments of the NDC number remaining the same. When a change occurs, there is a limited cases when you may update the listing without requiring a new NDC number. If there's a change in inactive ingredients that will be replacing an old formulation, then an existing listing may be updated. If the artwork has modifications that do not reflect information that affects the product code, then the existing listing may be updated, or if it affects the package code. An existing listing cannot be updated if there's a change to the package, like sometimes the size. If you change, like it may be the same within it, but if you change, like it's like 22.5 ounces, and then you go and change it to milliliters with what's on the actual artwork, it can get a little hairy with FDA if it doesn't match what was previously submitted before. If the labeler, registrant, or manufacturer information has changed, like the company name or DUNS number, the existing listing may be updated. That doesn't require, it's if the company changes altogether, like a PLD has a new manufacturer, then that product would have to be filed under a new NDC number using the manufacturer's labeler code. When a product is no longer being manufactured or marketed, listings must be updated to indicate that the marketing has been completed. If in the event a product that was previously marketed has been discontinued and the listing's been updated as such, but is now being resumed to market, then FDA expects to use that same NDC number that was previously filed and update the marketing status as back to active with the date that it's resuming to be on the market. So FDA does not want to see new NDC numbers for products that are resuming market. Listings must be updated when there is a change in marketing status, either when being discontinued or resuming marketing. If there's a change in the labeling that does not require a new NDC number assignment, then the new artwork needs to be uploaded into the listing. If the manufacturer's information has changed, it is important to keep that information up to date. And of course, the other companies named in the listing, such as the labeler or registrant, all need to be kept up to date when there are changes. To keep your product listings valid for an additional year without changes, it's essential to certify them as no changes through a separate FDA filing if they haven't been submitted during the current calendar year. This certification is only possible if there are no active compliance issues related to the NDC number and the manufacturer is properly registered with the FDA. The certification window is limited to October 1st through December 31st. Missing the deadline means your listings become uncertified, requiring you to manually resubmit the full structured product labeling SPL to the FDA. Additionally, if the manufacturer is not registered, the FDA will inactivate the listing, which could impact your product's market status. This process ensures compliance and continuity in your product listings, avoiding disruptions in regulatory status or market availability. Manufacturers hold the primary responsibility for maintaining and submitting accurate listings to the FDA. Private label distributors can only manage these submissions if they have explicit authorization from the manufacturer. Importantly, PLDs who do not engage in manufacturing, repackaging, relabeling, or salvaging drugs cannot register with the FDA under this regulation. Distributor is not a business function that is selectable under a registration submission. However, if a PLD acts as an authorized agent for a manufacturer, the FDA will accept their submissions provided the information relates to an establishment involved in those regulated activities. This distinction ensures compliance and proper accountability in the drug listing process, emphasizing the regulatory framework under 21 CFR Section 207, Part 17B. We discussed the requirements during the renewal period for drug submissions in today's webinar. This drug renewal period runs from October 1st to December 31st. It is required to renew the registration and certify listings during this timeframe. It is crucial to understand the consequences of missing this deadline. If you miss a deadline, the FDA inactivates registrations as early as January 1st. Facilities that are no longer engaged in manufacturing drug products must inform the FDA through electronic submission. It's important to note that inactivation by FDA does not relieve the firm of this responsibility. The FDA also inactivates listings at the end of January and July for noncompliance. This can happen if the manufacturer is not registered or if the listing is not certified by the deadline. Processing delays can occur as no change submissions will no longer be available after December 31st. So in other words, you cannot do no change notifications before October 1st, and you cannot do no change notifications after December 31st. So after December 31st, if you miss this deadline, you will need to file full SPLs. This process is more likely to run into validation issues and is more time consuming. So it's essential to stay on top of these deadlines to avoid any disruption in your operations. We have talked a lot in today's session about the various requirements that are required by the FDA. It is no longer to register annually, but quite a few more requirements have been added to the drug industry that requires maintenance throughout the year. We may not have talked about all those today. We were very focused on the renewal period, but I'd like to take a moment and just kind of give you a year's time look at all the requirements for manufacturers now that FDA has imposed on them. So when first engaging in manufacturing drug products, facilities are required to register and list its drug products. If the facility had listed drug products that indicated marketing occurred the year prior, then amount reporting would be required to be filed with the FDA for the previous calendar year by March 31st. Amount reporting per law is required for all drug products, human, animal, finished, and unfinished forms. In March is when the OMUFA, the over-the-counter monograph user fee amendments, facility fees are typically announced by the FDA. So that gives time for industry to remit payments before June 1st, the deadline. May 1st is when self-identification starts for facilities that are engaged in generic drug manufacturing. Those are part of an abbreviated new drug application, or they intend to be engaged in generic drug manufacturing. The deadline to self-identify is by June 1st. June, even though it's not noted on this timeline, is also the month that companies are required to update changes to listings in addition to the renewal period in the fourth quarter, October 1st through December 31st. During this period, manufacturers are required to update their registration or submit notification no changes to what was previously filed. Listings that have had no changes also must be certified through a blanket no change certification submission. Manufacturers of generic drugs also have facility fees to pay on the first business day of the fiscal year, which is typically October 1st. Also on this day, holders of ANDAs must remit payment to FDA for the ANDA program fee also by this date. So in summary, manufacturers do have a lot to track, and this is by no means an exclusive review of all the requirements that a company must comply with. But these are ones that are commonly missed, causing companies to be placed on public arrears lists, result in misbranding charges, and sometimes may jeopardize compliance for their customers. We help our clients ensure that they do not miss these deadlines by giving them reminders in advance, providing guidance when there are updates, and make the process as simple as possible. Infographics such as these are resources our clients find helpful with understanding the complex requirements set forth by FDA.
Thank you, Melissa. Before we go into our Q&A, we want to highlight the various compliance services we offer, as well as the wealth of master file services we offer. Also, online training to help expand your knowledge base. Our company, Registrar Corp, is a trusted partner for all compliance needs, and we provide a comprehensive range of services to help you navigate regulatory requirements seamlessly. Firstly, we assist with companies with FDA, ensuring that they comply with all necessary regulations. We also help with leveler code assignment, which is crucial for configuring national drug codes (NDCs) for drug products. Our U.S. agent services are designed to facilitate communication between foreign companies and the FDA, making the process smoother and more efficient. We manage product listings and assist with amount reporting to the FDA, ensuring that all necessary information is accurately submitted. Also, we offer DUNS assistance, helping companies obtain and manage their DUNS numbers, which are essential for FDA registrations. Our team supports the self-identification process required by FDA and helps companies obtain export certificate for their products. For biologic products, we provide biologic registration assistance. We also assist with licensure reporting requirements for third-party logistics, 3PL, and wholesale drug distributors, WDD, who handle human prescription drugs. In addition to these core services, we offer ECTD assistance with master files to agencies around the world. We also have online training to teach you about good manufacturing practices, GMPs, marketing pathways, and electronic records and signatures requirements under 21 CFR 11. Our goal is to ensure that you remain compliant with all regulatory requirements, allowing you to focus on your core business activities. Registrar Corp is a trusted compliance partner to more than 32,000 customers in over 190 countries. With 20 plus years in the business due to the 462 plus years of regulatory expertise in our company. We provide 27 services and software solutions to help the industries be compliant globally. We are also the only one that is ISO 27001 certified, ensuring that your data is secure when you choose us as your compliance partner. We appreciate you joining us today. If you have not done so already, please enter your questions into the question channel. We have few moments for questions. Thank you for your questions. Let's start with one. Is your GMP offering also translated to Spanish? The Register Corp also assists in Spanish and other languages. Our regulatory advisors are multilingual, so they will be able to assist you with any question regarding it. Let's see another great question. Do we need to update a listing if we have the same DUNS and labeler code, but we want to brand under a DBA fictitious name? Melissa, would you like to answer this question for us?
So basically, if it's all under the same ownership, legally, you would have one listing. If one site is manufacturing it, but then you're saying a different name is on the label and it appears very different, because there's no easy way for the FDA to know that it's all related, you would then fall under what is called like the dual listing requirement, where the manufacturer has its labeler code, you file it a listing, that's the contract manufacturer listing, and then a separate one is known as the PLD listing. And that's only possible is if that DBA has its own DUNS number by the Dun Bradstreet. So in order to do, you would have to have two separate DUNS numbers, and it would have to be listed twice if this listing is intended for use for human drugs. It's a good question.
Thank you. Thank you for your answer. Well, we're done with the questions for today. If you have further questions, please reach us out at registrarcorp.com. Well, thank you all for your assistance today.
Appreciate that, Sophia. Thank you so much. I I just want to take a moment for thanking you all for joining us today. As we close this webinar, we will be sending out a copy, so you'll be able to revisit this recording of this presentation. I want to emphasize the importance of staying compliant with FDA regulations. The renewal period for drug submissions is a critical time, and missing deadlines can have significant consequences. Remember, the FDA will inactivate registrations if you miss the deadline and listings. Processing delays can occur, making it more likely for submissions to run into validation issues. So our team here at Registrar Corp is here to support you every step of the way. Whether you need assistance with FDA registration, labeler code, product listings, or any other compliance needs, we also do, if you have other products, not just drugs, but medical device, cosmetics, food, etc., we do offer services for all those areas as well. So if you have any questions or need further assistance, as my colleague Sophia has already indicated, our information is up on this slide. Feel free to contact us. We are committed to helping you navigate the regulatory landscape and ensure your operations run smoothly. Thank you once again for your attention and participation. We know everyone's always so busy, so we really appreciate your time today. Have a great rest of your day.